How much is an Illinois workers' comp case actually worth? Kevin thought $32,000 sounded reasonable. He hurt his knee at a FedEx facility in Bolingbrook, had surgery, and has been out of work for 4 months. The insurance company sent him that number last week. His wife looked it up online and couldn't find a clear answer. So Kevin is thinking about taking it. What Kevin doesn't know is that $32,000 may be a fraction of what his case is worth under Illinois law. I'm Mark Connolly, a Chicago workers' comp attorney, and this video will give you the framework to evaluate any offer on the table. Let me be honest with you up front. There's no single number I can give you in this video that tells you exactly what your specific case is worth. Every case is different. The nature of the injury matters. The severity matters. Whether you can return to your prior job matters. Your average weekly wage matters. Your age matters. The quality of your medical documentation matters. But what I can do is explain exactly how Illinois workers' compensation cases are valued. And by the end of this video, you'll have enough information to know whether any number the insurance company puts in front of you makes sense or whether something is wrong. The first category, medical benefits. The employer insurance company are required to pay all reasonable and necessary medical expenses related to your work injury. Emergency room visits, surgeries, specialist consultations, physical therapy, prescription medications, diagnostic imaging, all of it. There's no copay or deductible on your end for treatment related to a work injury in Illinois. One thing to understand about medical benefits in the context of a settlement. When you resolve your workers' comp case, you need to know whether future medical is being closed out as part of the settlement or whether it remains open. This is a significant decision on serious injuries where future surgeries or ongoing treatment are possible. A settlement that closes out your future medical rights for a lump sum must be evaluated very carefully. Once you sign, that door is closed. The second category, temporary total disability. If your injury prevented you from working, you're entitled to TTD benefits while you're under active medical care and unable to work. In Illinois, TTD is paid at 2/3 of your average weekly wage, subject to statutory maximum and minimum caps published by the IWCC. These caps change periodically, and the minimum depends on your dependent status, so check the current IWCC rate chart for exact numbers. These benefits continue until you return to work, reach max medical improvement, or are released to full duty. On a serious injury with surgery and a long rehabilitation, TTD alone can be a substantial amount. A worker out for 6 months at a weekly rate of $900 in TTD accumulates over $23,000 in income replacement. That is real money, and it belongs to you under Illinois law. The third category, permanent partial disability. This is typically the most significant piece of any workers' comp settlement. It's the number most workers have the least information about. PPD compensates you for any permanent impairment resulting from your work injury, even after you've returned to work. Illinois uses a schedule of injuries that assign a specific number of weeks of compensation to specific body parts. These are the maximum values under the statute for a complete loss of use of that body part. For example, complete loss of use of an arm is valued at 253 weeks under the Illinois schedule. Complete loss of use of a leg is 215 weeks. A hand is 205 weeks. A foot is 167 weeks. An eye is 162 weeks. For partial impairment, the compensation is a percentage of the applicable maximum. So if you have a serious shoulder injury that results in a 35% impairment, the calculation starts with the weeks assigned to the arm, multiplied by 35%, multiplied by the applicable weekly PPD rate based upon your wage. The weekly rate used for PPD calculations is capped by statute, and the cap changes annually. But even at cap rates, significant PPD awards for serious injuries can reach well into the six figures. A 30 to 35% impairment of an arm or leg on a worker with a solid wage history can generate PPD alone in the $60,000 to $90,000 range or higher, depending on the specific facts and applicable rates. A concrete example to make this real. Let me walk you through an example. A 42-year-old warehouse worker earns $900 per week. He tears his ACL and has surgery. He's then out of work for 28 weeks before being released to modified duty. His treating physician documents a 30% impairment in his knee. TTD 28 weeks at 2/3 of $900 is $600 per week. Total TTD is 600 times 28 weeks, which equals 16,800. The knee is typically evaluated at the leg level. The leg is valued at 215 weeks under the Illinois schedule. 30% of 215 weeks is 64.5 weeks of PPD. At the applicable weekly PPD rate for a $900 earner, which is subject to the statutory cap, the PPD value adds tens of thousands of additional dollars to the case value. Medical expenses paid on top of both of those. His total recovery, handled properly, could easily be 3 to 4 times the initial $32,000 offer he received. That's the gap between what workers accept when they don't have information and what their cases are actually worth. Several factors push a case value in one direction or the other, and you should understand both sides. Higher value, more severe injury, surgery involved, long recovery, permanent impairment that restricts the type of work you can do, documented wage loss, evidence of ongoing pain or functional limitations, a strong treating physician with clear and consistent documentation. Lower value, minor soft tissue injury with a quick recovery, no surgery, no documented permanent impairment, pre-existing conditions that the insurance company can argue caused or contributed to the injury, delay in reporting gaps in medical treatment that create questions about whether the condition is related to the work injury. The insurance company's job is to find everything in that second column. Your attorney's job is to build the case in the first column with medical evidence, consistent documentation, and legal argument at the Workers' Compensation Commission if necessary. What to do if you have an offer in front of you. If you received a settlement offer and you're not sure what to do with it, the most important thing is this: do not sign anything. Call an attorney. A free consultation is not a commitment. It's just information. Tell them the injury, the medical history, the TTD you received, and the offer on the table. A workers' comp attorney can give you a framework for whether that number makes sense or whether it falls short. The difference between accepting the wrong offer and getting the right one can be the difference between financial stability and struggling for years over an injury you got at work. That is not an acceptable outcome when help is available at no upfront cost. If your claim has been denied or you received a lowball offer you want to contest, we have a video on this channel covering exactly what happens when workers' comp denies your claim in Illinois and what your options are. Subscribe so you do not miss it. And if you want to talk about the specific offer in front of you, Connolly Injury Law offers free consultations. You have nothing to lose by making that call.